Hello and welcome. I am Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. And today I want to explain a concept, right? The concept I want to explain is like what is mandatory detention versus what is non-mandatory detention, all right? And you might have heard in either other of my videos or with other immigration lawyers throw out the term mandatory detention, all right, which is covered in 236C of the Immigration Nationality Act. If somebody is subject to mandatory detention, all that means is that the government has to detain them, all right? And it doesn't mean that they have to. It means that if the Department of Homeland Security has detained them, then the immigration court system really does not have jurisdiction over that person's bond. Like the immigration judge can't say to release a person, you're not going to be eligible for a bond if you're subject to quote-unquote mandatory detention, all right? And typically, if you are subject to mandatory detention, then DHS is not going to issue a bond period, and you're going to be detained throughout the life of your case, all right? With certain exceptions, and I won't go into those exceptions for now. All you need to know for now is if it's mandatory detention, what that means is that the government has to detain you. And now what would cause that? Really, it's certain crimes, all right? It's certain crimes. If you have certain arrests and convictions in your past, all right, and if it's after those arrests or convictions that you've been transferred to ICE, then you very well could be subject to mandatory detention, depending on under what code section you were actually convicted, all right? And I want to make sure I'm clear, 236C does require a conviction for that issue. It's not just an arrest. It actually, if you were convicted of certain offenses, you'll be subject to what they call mandatory detention, all right? Versus non-mandatory detention. Non-mandatory detention, they might still detain you. They might still detain you throughout your whole case, all right? But if you're not subject to mandatory detention, it means you might be able to request a bond to get out of there. And a judge might say, you know what? Yeah, you're not subject to mandatory detention, so we're not by force having to detain you. The judge might say, look, I'm going to detain you anyway, all right? But at least you have the argument to present a case in front of the judge to request a bond hearing to put on arguments that you should be released, all right? So that's the main difference. Mandatory means there's no argument to get out of there. Non-mandatory, it doesn't mean you're going to be released. You might still be detained, right? But at least you've got a shot, and typically you get one shot to request a bond hearing in front of an immigration judge. And so take advantage of that shot, all right? And hire a lawyer that actually knows what they're doing, and let's put on all the arguments possible to maximize your chances of getting out of there, all right? So thank you for watching. That's all I've got for today. I hope that cleared up the distinction between mandatory and non-mandatory detention. I am Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C. If you found this useful at all, please subscribe to our channel. Please click like or give us a thumbs up or whatever it is here on YouTube. And thank you so much for watching. I'm Otis Landerholm, Landerholm Immigration A.P.C., where we fight for your American dream. Thank you.